A sessão que nós temos agora é uma sessão que tem como tema central o direito à verdade em alguns aspectos jurídicos. Nós teremos duas exposições. Em primeiro lugar, teremos a exposição da Leora Bilsky, que é professora da Universidade de Tel Aviv, da sua Faculdade de Direito, e o tema dela é o direito à verdade transforma a figura da testemunha. A professora Bilsky é uma excepcional jurista, tem lidado com os problemas de verdade, testemunho, narrativa, na análise de uma série de casos jurisprudenciais, em especial decisões das cortes israelenses. É também uma grande conhecedora da obra de Hannah Arendt, que o nosso professor Tércio elencou em diversos momentos da sua exposição. Depois da exposição da Leora, a Carla falará, como eu disse, sobre o direito à verdade, a questão jurídica. Carla defendeu uma excelente tese de doutoramento na faculdade, que é a primeira tese entre nós sobre, enfim, o que é o direito à verdade, quais são as suas origens jurídicas, o que ela significa e quais são os desafios presentes num conceito recente como este. Tanto a Leora quanto a Carla, em princípio, farão uma exposição de meia hora. A seguir, nós temos comentadores que serão sábios no uso do seu tempo e que são, respectivamente, a Ariane, a Camila, a Elza e o Humberto Celli, que estão todos próximos aqui neste círculo. Então, sem maiores delongas, eu vou passar a palavra à Leora, que falará em inglês. E fiquem satisfeitos que ela não está falando nem em hebraico, nem em alemão, nem em árabe.
So, thank you, and oh, okay. I'll stand up a little bit because of my back, but thank you for agreeing to listening to me in English, and thank you for Professor Lafer who brought me here, and thank you for the great invitation. I'm very excited to be here. I wanted to talk about the Eichmann Trial, and I want to somehow connect it to the issues that we deal about here, mainly to what we heard now in the presentation, to the distinction between documents and witnesses, documents as history and eyewitnesses and memory, and try to connect it to the issue of truth and the context within which we verify something as true or untrue. So much has been written about the Eichmann Trial. Some criticize the trial for being mere political or Jewish trial, and others focused on its narrow contribution to international law. In my view, the Eichmann judgment was overshadowed for many years by the Nuremberg Trial, that is considered till today the more important precedent for international criminal law. Thus, scholarship on Holocaust trials tend to view these two paradigmatic trials as fulfilling two distinct functions. The Nuremberg trial, which relied primarily on written documents to convict the defendant, is seen as having contributed to the development of international criminal law. In contrast, the Eichmann trial, in which victim testimonies took center stage, is seen as having contributed to extra-legal goals, such as the formation of a collective memory of the Holocaust. I would like to suggest that the inability of international law to see the contribution of the Eichmann trial to international law stems from a misconception of the trial as a Jewish trial, due, among other things, to the category that was used there, crimes against the Jewish people. This misconception was fostered to a large extent by Hannah Arendt, whose influential book, Eichmann in Jerusalem, has conserved the Eichmann trial in world memory, but also delegitimized it as a political trial. In particular, Arendt objected to the role given to victims' testimonies, which she described as testimonies of suffering, irrelevant to proving Eichmann's guilt. In a groundbreaking article published in 2013, Professor of International Law William Shabazz argues that the Eichmann decision is an important precedent for international law, and that the trial's critics at the time were wrong not to see its legal contribution. Yet, a central point in the Eichmann trial is absent from Shabazz's analysis: the transformation in the status of the victim in atrocities trial. And this, although it is precisely this issue that has been the subject of tremendous developments since the early 90s in international criminal law. I argue that the Eichmann court developed an innovative jurisprudence that confers recognition and importance to the testimonies of individual victims in the trials of the perpetrators of collective crimes. I identify 3 building blocks in the transformation of the victim's role. So 3 things happened in the Eichmann trial to allow hearing to the victims. First, a novel interpretation of the crimes against the Jewish people as genocide and crimes against humanity. This was different from what happened in the Nuremberg trial. Second, there was a new theory of modes of liability specific to collective crimes. And third, there was a new interpretation of the social value protected by such crimes that systematically attack what the court called the humanity of the victim. So I want to add by arguing that the narrative offered by the Jerusalem court in the judgment of Eichmann foreshadows recent developments in international law that call for the recognition of a victim's right to truth. So let me begin with the difficulties of seeing it. I believe that the difficulty in seeing Eichmann's trial contribution to international criminal law stems from the fact that the indictment was based on the category of crimes against the Jewish people, a category that is unfamiliar in international law. Historian Donald Bloxham writes that the Allied reticence at Nuremberg from addressing the race-specific crimes of the Nazis stemmed from a liberal universalistic refusal to single out the treatment of any group as unique, together with the fear that a full exposition of the Holocaust would distract attention from the theoretically based conspiracy charge of waging an aggressive war that stood at the center of the Nuremberg trial. So it can be speculated that this approach, prevalent among international scholars, has made them long ignore the Eichmann trial as a precedent for international law. Moreover, Arendt's criticism of the reliance on crimes against the Jewish people as articulated by the Israeli law instead of the category of crimes against humanity, that is more universal, further prevented international legal scholars from seriously engaging the Eichmann decision. However, if we look at contemporary international criminal law, we see that what we call the atrocity framework that was marginalized at Nuremberg, because Nuremberg was about aggressive war, not about genocide or crimes against humanity, became central in the Eichmann trial. This is the center of the trial. And this framework became central in international criminal law since the 1990s. So accordingly, I argue that in comparison with the Nuremberg trial, the Eichmann trial carries the more relevant legacy for today's international criminal law. Contrary to Nuremberg Trial, at the heart of Eichmann Trial stood the categories of crimes against the Jewish people and crimes against humanity. The court, therefore, had to deal with international criticism, in particular regarding the illegitimacy of crimes against the Jewish people. And the court responded to this criticism by pointing out that this category, crimes against the Jewish people, is not an Israeli invention, but an accurate translation of the crime of genocide as defined by the International Convention. However, unlike the Genocide Convention, which was prospective in effect, the Israeli law applied retroactively to the genocide committed by the Nazis. Hence, it was limited to this idea of crimes against the Jewish people. If we manage to see beyond the dispute over the particularism of crimes against the Jewish people, we see that at the heart of the Eichmann Trial stood the newly defined crimes, crimes against humanity and genocide. So this was the first innovation of the court. The second, it had to deal with a new type of criminality, and this is connected to what we heard before. I would call it systematic or organized crime. These are large-scale crimes requiring a high degree of organization carried out as part of an officially sanctioned policy based on mobilization of a large number of participants and affecting large numbers of victims. And in order to do this, of course, you need narratives of justification. Either it's the Cold War or it can be other justifications, but it cannot be like a typical individual crime. So such crimes pose a major legal problem, as domestic criminal law is premised on individual responsibility. And when it does apply to a group of criminals, the ordinary division of responsibility usually differentiate between the physical perpetrator, the torturer and so forth, and the accomplices, the people who helped. The Israeli court was not satisfied with the legal outcome of the traditional division of responsibility between principal and accessories present in domestic criminal law, and therefore it developed an original theory of responsibility for participation in these organized collective crimes. And this, I think, goes back to what we heard yesterday about the concept of authorship that your Truth Commission is trying to devise. I think it's very similar to the problem that the Eichmann Trial is trying to deal with here. So what the Eichmann court had is what we call today joint criminal enterprise. And this doctrine is meant to extend the mode of participation in a crime as part of a larger criminal enterprise, in order to understand it. So to reach perpetrators higher in the ranks of bureaucracy, Nuremberg relied mainly on the doctrine of criminal conspiracy, but in the Eichmann trial, because it was domestic criminal law, the court didn't want to rely on conspiracy, because with conspiracy you can actually destroy the criminal law, because you don't need to distinguish individual guilt, and it was very dangerous to the liberty of citizens in Israel if ordinary courts apply a very wide understanding of conspiracy. So in order to cope with the difficulty of establishing Eichmann's responsibility, the court proceeded in two stages. First, the court distinguished between the responsibility of an accomplice in a standard criminal trial and the responsibility of those who would appear to be accomplices in the final solution, but are in fact, the court said, they are not just accomplices, but in fact they are principally responsible for these crimes, even though they might have never physically murdered any person, right? Second, it developed this idea of joint criminal enterprise responsibility that permits to impose criminal liability on defendants who did not themselves personally commit the crimes in question. if it was proven that they entered a common plan to commit these crimes and participating in furthering this plan, and also had a central role in this plan, as was with Eichmann. So the court analyzed the crime against the Jewish people and found that it is a collective crime by its nature, both from the perspective of criminal intent, which is not directed toward a specific victim, but towards a whole group, and from the perspective of the criminal act, which is dependent upon an apparatus, coordination of actions of a vast number of persons in different places as part of the same extermination mechanism. And from this collective nature of the crime, the court derives Eichmann's participation as principal in this crime, and the court writes, whoever collaborated in the extermination of the Jews with knowledge of the plan of the final solution and for its furtherance is to be regarded as an accomplice in the extermination of millions who were destroyed during the years 41-45, irrespective of whether his actions extended over the entire extermination front or only over one or more sectors of it. His responsibility is that of a principal offender who has committed the entire crime in conjunction with others. So this is the theory of participation in the crime. And the third innovation, which I think this is the most relevant to your context, is the role of the victim in this. A new role for victims' testimonies. So what we see in the Eichmann trial, we see that the Justice Landau, who presided over the trial, he was a very formalist and conservative judge. And still he allowed the testimonies of about 100 survivors that most of them have never seen Eichmann in their own eyes. So this seems to be a contradiction. How come you allow them? So most scholars who wrote about it said, yes, so this shows that this is a political trial. It's not a legal trial. Or that it's just a contradiction, but it cannot be explained. So, but I want to convince you that we can see it in a different way. I want to argue that the court's new interpretation of crimes of the final solution as collective crimes, together with the articulation of a new mode of participation, combine to legitimize victims' testimonies and to make them an integral part of the legal investigation. That is, the victims' testimonies in the Eichmann trial were not merely a didactic tool in the hands of the prosecution for teaching history and constructing memory, as usually is understood. While most historical studies of the Eichmann trial focus on the public transformation of the figure of the victim that the trial occasioned, yes, by moving from, in Israel, the focus was on partisans and resistance fighters, and the Eichmann trial moved us to look at the victims. So this is what most people are interested in. I would like to point that in addition to the legal transformation in the meaning of eyewitness testimonies of victims in such atrocity trials has occurred in this trial. So, but before I just give an example for this, I want to go back for a minute to the Nuremberg trial in order to actually shortly explore the prior attempts of Jewish victims' organization to participate and shape the international jurisprudence of atrocity crimes. It is now common knowledge that the architects of Nuremberg trial preferred to build the prosecution case on documents and not on victims' testimonies. However, it is less known that the attempt of Jewish organizations and Jewish victims to change this aspect of the trial. New historical research on the origins of international criminal law reveals this unfamiliar episode. For example, a very interesting book that just came out this summer, it's by Mark Lewis, in the book The New Justice, shows that the Jewish organizations and victims' organizations were active behind the scenes. They asked for the recognition of a new crime against the Jewish people, the appointment of a prosecutor representing Jewish victims in Nuremberg, right? And allowing for the testimonies of Jewish victims in this trial. These legal demands did not come out of nowhere. Historian Leora Bilsky argues that the category of crimes against the Jewish people was born in Jewish DP camps, where several trials against Jewish survivors who collaborated with the Nazis were conducted, and if they were found guilty, the defendants were declared traitors of the Jewish people. So that's where it began, actually. Even more important for our purposes, there was a strong link between what we call today victims' right to truth and what was then understood as victims' right to write the history of the Holocaust or of the Shoah, and the legal demands of victims' participation in the trial as a result of it. So this is almost unknown, but historians reveal this. In the wake of World War II, the Jewish victims in DP camps all over Europe, yes, organized what we call historical commissions to investigate the history of the persecution of Jews in the Third Reich, and this led to an internal debate between two approaches to history writing within the victims community. There was the expert history approach and the victims or memory approach to the fact, right? And the approach that won the day was based on a collective memory understanding of history. And I think it's not by mistake, because it is a Jewish tradition usually give priority to memory over history for different reasons, right? So this approach saw that the writing of history belongs to the victims' community and not to expert historians. And in this democratic approach to history, each victim was called to testify or write down his or her testimony. The historical committees that were established by the Jews collected these testimonies as valuable to history, but also as evidence for future war crimes trials. Although the information that was thus collected was historically valuable, the architects of Nuremberg Trial refused to accept these testimonies. And this material was transferred to Yad Vashem in Israel, the institution that deals with this history. Here we can find the link to the Eichmann Trial. Initially, the Israeli police built its case in a conservative way on the basis of Nazi documents, just like in the Nuremberg Trial, and on eyewitness testimonies of about 30 survivors that they said you can choose between them, that not all of them are necessary. However, there was a woman called Rachel Auerbach, who was a Holocaust survivor and a lead researcher at the Yad Vashem Institute, and she convinced the Attorney General, Hausner, to change his conception of the trial. She had earlier been a major proponent of what we call the memory approach. And Hausner adopted her approach. And he saw crimes against the Jewish people as standing at the center of the trial and called for more than 100 Holocaust survivors to testify in the trial. Thus, the approach that was rejected in Nuremberg was adopted in Eichmann Trial. Notwithstanding this revolutionary conception of the trial, it is important to distinguish between the Israeli prosecution that really adopted a memory approach to the judgment, to Justice Landau, who did not adopt a memory approach. So I would say that the memory approach of Hausner is something like what we heard yesterday of a truth commission, right? That you allow the victims to testify however they want, whatever they want, just to give their stories. The court was a criminal court, and it was uncomfortable with introducing such extra-legal goals such as history and memory into the trial. So I would like to emphasize that this difference led the court to articulate a new legal role for victims, not just memory role for the victims. So the Israeli court chose to overcome the gap between the desk murderer and the victim by intertwining the perpetrator's documents, which were important part of the trial, with victims to create what we call today an integrated narrative of the crimes of the final solution. And in doing so, it offered a novel understanding of this facet of the new crime, which separates and distances between victim and victimizers. Crucially, this approach by the court was not taken solely for extra-legal reasons. So I have several examples, but I'll give you just one example. I don't want to take too much time. So how does the court weave together the documents and the testimonies? So, for example, Eichmann presented himself as an expert on transportation and testified at length on transportation conditions. By the way, he also admitted completely the final solution. All of these crimes, he said, yes, that happened. It's just that I was only obeying orders, and I was only responsible for transporting the Jews to wherever, yes? So in contradicting his testimony of ignorance over the actual conditions of these transports, the court juxtaposes the document, the Nazi document, with the witness testimony. So first the document, the court says, from the minutes of the meeting, the document, which took place in Monkat between representatives of the Hungarian gendarmerie and the German Gestapo, we learn about transportation conditions. A Hungarian officer remarks, if necessary, even 100 people can be put into a single carriage. They can be packed like salt herrings, for the Germans need strong people. Those who cannot hold out will fall. Fashionable ladies are not needed there in Germany. That's according to the document. And the court continues about it. Thus, Westenmeier reports on May 25, 1944, on the increased exploitation. This is how they describe it. This is the objective document, right? The increased exploitation of the railway cars, enabling a much quicker completion of the evacuation program from Carpato, Russia. Then the court turns to incorporate the testimony of a Jewish victim. And that's what the court says. Mr. Ze'ev Sapir gave evidence about the transportation of Jews from Monkat. The whole community of 103 persons were loaded into one freight car without food and without water for the whole 3 days journey to Auschwitz. End of quote. This juxtaposition manages to break down the jargon of the document, transmitting the human experience for the Jewish victims and revealing that one freight car meant the elimination of an entire community. This testimony also reminds us of the inhumane transportation conditions without water and food for 3 days. To conclude this point of transportation conditions, the court cites from the testimony given by Hansi Brandt, who testified that when she and Dr. Kastner came to Eichmann, they negotiated with Eichmann, right? That's what she said. With the news about that 100 people had been loaded into one car, this is how he, that is Eichmann, this is how Eichmann reacted. And he said, he told us, we were not to worry, because this only concerned Jews from Carpatho Russia, whose families were blessed with many children. These children, therefore, did not need so much air and so much room, and nothing would happen to them. This is how Eichmann described. So this is an example of how the court ties together documents, testimonies, and eyewitness testimonies in order not only to prove Eichmann's link to the actual crime that has been committed in the person of those transported, but also his mental state during the commission of this crime. It also allows us to clearly see the way the crime was meant to undermine the humanity or the dignity of the victims. So this is, do I have more time? So this is the example, but I have more examples. So now I want to reflect on this and to say, what is the historic counter-narrative that the court's judgment offers by weaving together the Nazi documents and the survivors' testimonies? We heard before that we cannot really get to the facts without a narrative, without a historical narrative that explains them. And I think that an important part of what the court is suggesting is a counter-narrative to what was offered in the Nuremberg Trial, a narrative of history that did not include the victims. So what is it that the court is trying to do here? Here I would like to refer to a very famous historian, Saul Friedlander, in his book Nazi Germany and the Jews, in which he explains that he sought to bridge the gap that became increasingly institutionalized among general historians and Jewish historians. This gap coincides with the choice of materials, back to you, dividing between historians writing solely on the basis of documents, of the perpetrators, such as Raoul Hilberg, and historians who write on the basis of testimonies and diaries of the victims. And Friedlander, unlike previous historians of the Third Reich, introduced what he termed an integrated history, which wove together the perspective of the perpetrators, the attitudes of the surrounding societies, and the experience of the Jews. He said all three have to be part of this narrative. I don't want to go into details into it, but just to suggest that I think the Eichmann judgment, previous to Friedlander in about 40 or 50 years, has tried to do just this, to create an integrated history, but not for historical reasons, but mainly for legal reasons in order to allow it to judge Eichmann. So what Friedlander says about the importance of integrating the victims' testimonies, looking at the same event from two very different perspectives, back to Arendt's and the plurality of points of view, Friedlander writes, by its very nature, by dint of its humaneness and freedom, an individual voice of the victim, suddenly arising in the course of an ordinary historical narrative of events, such as those presented here, can tear through seamless interpretation and pierce the most involuntary smugness of scholarly detachment and objectivity. It is essential to the historical representation of mass extermination and other sequences of mass suffering that business as usual historiography necessarily domesticates and flattens. So what Friedlander asks us to have in mind is this disbelief, that the victims, shock of disbelief, that the victims' testimonies bring with them. And the Eichmann court is doing just this. He opens its narrative of the victims by citing two victims, two eyewitnesses. The most famous is Katzetnik, who collapsed, but the other is a survivor who later became a justice of the Israeli Supreme Court, Moshe Beisky. And he's a very rational and logical man. And he is questioned as a witness, as an eyewitness, by the prosecutor. The prosecutor asks him, 15,000 people stood there, and opposite them, hundreds of guards. Why didn't you attack them? Why didn't you revolt? That was the question put to him. And this is what Bilsky answers in the court. He says, it is no longer possible, even for us, and I admit this, to describe the feeling of terror 18 years later. As I stand before your honors, it no longer exists, this terror. And I do not think it is possible to impart that feeling to anyone. The conditions existing at the time cannot be conveyed today to the courtroom. Not that I think, God forbid, that someone may not understand this, but even I myself cannot do so, and I felt it on my own flesh. So it's really this impossibility to bridge this gap between then and here and keep this moment, even though the court is going to give you a narrative that is chronologically and geographically analytical, it puts this as a warning sign for us and to say, look, these testimonies are important also for this, to give us this impossibility that we are doing something, and while creating the history, we are falsifying the history because we are making it look rational or comprehensible, but it's not. It's not even for me as a victim. As someone who was there, I cannot really reproduce this feeling for you in the court. So let me end here and say, much like the historian, the judge, many years earlier, wishes to keep the shock of disbelief by juxtaposing the points of view of perpetrator and victim. You know, for the perpetrator, 100 people in a carriage is efficient. For the victims, it's a whole community that disappears in one day. So that's something that is unbelievable. So it does it by integrating testimonies and documents. And second, not only by integrating them, but by preserving the unbridgeable gap between the world of the victimizer and the world of the victim, the trace of which was to be found in the witness collapse on the stand. So this is important. So thank you.